And you are here with AB 2879
Yeah,
as well?
AB 2879, Service Member Employment Protection Act. I believe I do have some witnesses here, so as they come forward, let me get started on this bill. Over the last couple of years, this legislature has debated, bills have come to the floor dealing with the issue of arbitration and whether forced arbitration and mandatory arbitration is something as a matter of public policy we want to encounter. There's a particular circumstance that came to light through that conversation that this bill is trying to address. And because as we have that broader conversation about whether or not forced arbitration clauses in an employment context are appropriate, not appropriate, when we're talking about service members, active duty military, or folks who are in the reserve, I think we have a very specific concern to raise, and that's what this bill is trying to do. I would actually like to take that population off the table and out of the conversation around the arbitration clauses and the way that we do that. That's the intent here. Because and you're going to hear from the wife of a service member who lost their job because that individual was forced into arbitration, and the arbitrator in that sense got the federal law wrong and applied it incorrectly in that case. And because it was a mandatory arbitration clause, there was no remedy. There was no way to fix that problem because there was no court jurisdiction. Federal law, the USERRA law, and even state law gives protections to folks in active duty military or in the reserves that says that nothing that an employer does has in that relationship with the employee can abrogate or infringe on their rights as a service member. We don't want an employer taking it out on a service member if they go off to reserve duty, if they have to go off on active duty. We want to make sure they get their job back. We want to make sure that that relationship is inviolate. But it doesn't work that way when an arbitrator misapplies the law. And I think we've seen cases of this again and again and again. I think this is an important enough population. I think this is a group of individuals that we need to protect, have an obligation to protect under federal law, that if we pass this bill, that we would take them out of that conversation. We would still have the conversation around arbitration clauses in an employment context, but not to the detriment of our armed services, our military folks. That's the intent of the bill. That's what we're trying to do in this case. And I have Darcy Lively, who's the wife of Major Stephen Lively, wrongfully terminated in California. She's traveled from out of state because he's been reassigned to another part, to talk a little bit about what the circumstances were. And I have James Luby, the Executive Director of the National Guard Association, and Elise Sanguinetti, the President of the Consumer Attorneys, to offer some technical perspective and answer any questions here. And again, let me underscore, I know this has been placed on the job killer list, which is a bit astonishing since what we're just trying to do is protect the jobs of our service members. And my intent here is to take those service members out of the fight that we are having and will have over forced arbitration clauses. That's the intent of this bill.
All right. Thank you. Your first witness in support.
My name is Darcy Lively, and I've been a family readiness leader for the United States Army Reserve for 13 years. In this position, I am the first line of support for soldiers and their families for everything from finance questions to marital problems, employment issues, and even the death of a soldier or family member. But the most important role I fill is that of being a military wife to my husband, Major Stephen Lively. Reservists face the unique challenge of finding balance between serving two masters. Often, civilian employers are only interested in hiring soldiers once they have permanently separated from the military. They are usually sought after for their work ethic, character, and integrity. When an employer hires a reservist, it is with the understanding that the soldier will need to be released from their civilian role if called to drill for trainings or deployment. My husband is deployed 3 times, 2 times to a war zone. Each time he walks out the door, we as a family put our family life as we know it on hold and wait for his return. Also, like other reserve families, we took the opportunity during his last deployment to move closer to family to strengthen our support circle while my husband was away. Returning to a new city and a new home, my husband looked for new employment upon his return and took a position with a company located in Rancho Cordova. He was under the impression that they were supportive of his dual career and filled out the requisite entry paperwork as anyone would if they wanted the job they were offered. Just 2 months into his new position, my husband began to be harassed by the management of his company each month around the time of his drill. The harassment escalated with extra project assignments and heavy travel until my husband missed a drill weekend in fear that he would lose his civilian employment if he failed to meet seemingly unobtainable deadlines. Eventually, my husband was forced out of the company. We began immediately to seek legal representation and were informed that we would need to take our case to binding arbitration. We were told the binding arbitration paperwork was tucked into the new hire packet he signed before starting with the company. We had no idea what binding arbitration was. We actually thought it was mediation. After speaking with almost 25 attorneys, we were able to find someone to represent us in our case where we claimed the company had broken USERRA law and state law under Military and Veterans Code Section 394. It was almost a year before our case was tried. The arbitrator in our case refused to shift the burden of proof to that of the opposing side, as was required under USERRA law and Military and Veterans Code 394, and the time with which we had to present our case didn't allow for all witnesses to be heard. The final verdict was in favor of the company, and when we received the final brief, it contained a scathing defamation of my husband's character written by the arbitrator. Due to the nature of binding arbitration, there was no recourse to hold the arbitrator accountable for disregarding the law. It just ended, and we were left to pick up the pieces and find a way to move on. My husband was devastated by the outcome. I began to see a change in my husband's confidence that has colored his actions with subsequent employers to this day. He began by burying his military service in his resume and sometimes taking it out altogether. His mention of his military service diminished as well. Another soldier who testified in our case and worked for the same company had a similar story. Travis returned from combat with PTSD. When he returned to work after deployment, he was informed that his position was no longer located in California but in an eastern state, and that he would need to fly back east each week to keep his position. The company was furnished with a doctor's note and informed by ESGR, Employer Support of the Guard and Reserve, that Travis's PTSD was triggered by flying. With the hope of keeping his position as sole breadwinner for his family, Travis began to self-medicate by drinking alcohol and taking sleeping pills while suffering nosebleeds just trying to board the plane to keep his job. Travis was also forced out of the company and found himself in binding arbitration with a less than desirable outcome. My husband describes binding arbitration as arriving to play a football game only to find out that the opposing team has paid for the refs. Binding arbitration deprives soldiers of their constitutional rights they so valiantly and selflessly swear to defend. The system we believed would protect our family for our sacrifices is broken. Justice was not served.
Thank you. Additional witnesses in support.
Chairman and members, I'm Jim Luby, the Executive Director of the National Guard Association of California. The purpose of the National Guard Association of California is it's chartered primarily to serve as a charitable nonprofit organization and to extend and perpetuate the sound interests of the California National Guard, the State Military Reserve, and the Naval Militia by every appropriate means. The California National Guard is a federally and state-funded California military force, part of the National Guard of the United States. It comprises both Air and Army National Guard components, and in fact is the largest National Guard force in the United States, with a total authorized strength of approximately 20,000 service members. The Constitution of the United States specifically charges the National Guard with dual federal and state missions. When under the control of its state governor, the National Guard functions from limited actions during emergency situations to full-scale law enforcement or martial law when local law enforcement can no longer maintain civil control. The National Guard citizen soldier may be called into federal service in response to a call by the President or Congress. When National Guard troops are called to federal service, the President serves as Commander-in-Chief. The federal mission assigned to the National Guard is to provide properly trained and equipped units for personnel.
Sir, if I could get you onto the subject of this bill, we all recognize and greatly appreciate the National Guard. Thank you.
The job of the nation's citizen soldiers are supposed to be safe while they are serving their country. Federal law does not allow employees to penalize service members because of their military duty. The reserves and National Guard leave their jobs and families to serve our country and state. Yet every year, thousands of National Guard troops coming home from Afghanistan and elsewhere find they have been replaced, demoted, denied benefits, or seniority. With good jobs still scarce in many states, and right now approximately as high as 50% in some California units, this has created a potential obstacle to serving. This bill will safeguard employment protection for civil service members, the Minutemen, while they are on active duty by prohibiting a waiver of certain legal rights under Section 394 of the Military and Veterans Code. This bill would enact the Service Members Employment Protection Act. It is a very important legislation that provides several key protections to ensure military service members do not voluntarily waive any of the employment rights. This bill will prohibit employers from requiring a civilian/service member on active duty or on reserve duty as a condition of employment to waive any of their rights. It includes the right to file and pursue civil action. We'll make sure that no waiver of any legal right under Section 394 must be knowing, voluntarily, and not made a condition of employment. The National Guard Association supports AB 2879, and we ask your vote.
Thank you very much. Additional witnesses in support.
Yes, good morning. My name is Elise Sanguinetti. I'm the president of the Consumer Attorneys of California. I'm going to keep my comments very brief. Our military men and women should not be forced to give up key legal rights, including the right to a jury trial, when they are illegally fired because they answered the call of duty. I will be here to answer any questions related to any of the preemption issues or any other issues that are raised by the opposition, and I respectfully request your A vote.
Thank you. Additional witnesses in support, please just name affiliation.
Mariko Yoshihara with the California Employment Lawyers Association. Strongly urge your support.
Thank you, Mr. Chair. Members, Megan Brightwell on behalf of the California Professional Firefighters in support.
Thank you, Mr. Chair. Members, Mitch Seaman with the California Labor Federation, also in support.
Mr. Chair and Member Shane Gussman on behalf of the Teamsters, the Amalgamated Transit Union, the International Longshore and Warehouse Union, the Machinists, and the Utility Workers Union of America in support.
Mr. Chair and members, Kevin Baker from the American Civil Liberties Union of California. Those who fight for our freedom and constitutional rights should not be forced to give up their own. Thank you.
Thank you. All right. Witnesses in opposition.
Good morning, Mr. Chair and committee members. Jennifer Barrera on behalf of the California Chamber of Commerce, and we are opposed to AB 2879. Our opposition has nothing to do with opposition to our military members. We value their service and their sacrifices just as much as anyone else. The sensitivity of the group at issue is not the impact of the analysis with regards to this proposal. Last year, a very similar proposal came forward, AB 465, that dealt with employees who were having their wages stolen. Again, a very sensitive issue, similar to military members, and we aren't opposing it based upon whether or not we support or don't support military members. Actually, has nothing to do with the analysis. The entire analysis deals with treating arbitration clauses differently than you treat any other protection or any other contract provision in a contract. And so that is what the basis of the opposition is about. Similar to AB 465 last year, this proposal basically tries to deem a arbitration agreement made as a condition of employment with a military service member as unconscionable. Now, the Federal Arbitration Act does provide a savings clause for contractual defenses that are applied in general to all contracts. Unconscionability is a general contract of defense. Basically, the courts look at it on a very factual basis and deem whether or not a contract is too one-sided or unfair to one side, and that deems it unconscionable. This bill, however, doesn't just utilize the general contract defense of unconscionability, but it specifically states that for purposes of a member of the military who signs an employment arbitration agreement, it is deemed per se unconscionable if they waive their right to a jury trial with an arbitration agreement. Now, you can have a member of the military service in an employment agreement agree to wages, agree to how their employment's going to be carried out with regards to if they're terminated for just cause or at will. You can agree to a ton of different contract provisions as a condition of employment, and it won't be per se unconscionable. So you're treating an arbitration clause in an employment agreement differently than you treat any other contractual provision in the employment agreement that may be made as a condition of employment. And that is what the Federal Arbitration Act has specifically said states cannot do. You cannot discriminate against arbitration clauses as a part of a contract. That was recently reemphasized by the United States Supreme Court in December of 2015, just this last year, with DirecTV versus Imburgia, which was delivered by Justice Breyer of the court. And he basically said to the California court in a basic civics lessons in the opinion that you cannot treat arbitration clauses differently than you treat any other contractual provision. If this proposal said that basically all contracts cannot have arbitration agreements, or it's deemed unconscionable for anything to be waived as a condition of employment, then maybe that would be a different analysis, but it is targeting arbitration clauses. Same thing with consumer agreements. You can have a military member sign a consumer agreement waiving arbitration, but you couldn't have it for an employment agreement. This illustrates the point that you are treating the defense of unconscionability for an employment agreement differently than you treat all other contractual provisions. So from our perspective, it's also preempted by the Federal Arbitration Act. It's no different than AB 465 last year that I just mentioned, dealing with the wage theft that employees face. Governor Brown vetoed it because he basically stated it was too far-reaching and that he wanted to see the pending Supreme Court case before he made a determination. Well, the pending Supreme Court case is the one I just mentioned, and they also deemed that the California courts had treated an arbitration clause differently than any other contractual provision, and therefore was preempted by the Federal Arbitration Act. If this proposal were going to affect, you put employers in a very difficult litigation dilemma. One, they're going to have to basically battle whether or not an arbitration provision that is subject to this proposal is preempted by the Federal Arbitration Act and take it through the courts, which takes a long time for litigation. And two, here in California, several years ago, Assemblymember Salas carried a bill that included military members as a protected class under the Fair Employment and Housing Act. Much like other provisions of the Fair Employment and Housing Act, it's something that we don't inquire into at the time of employment because we don't want to have the appearance that was utilized as a part of the employment decision, just like age, marital status, medical conditions, etc. We don't ask about those issues in an application or the employment process because we don't want to have the presumption that any employment decision, whether it's hiring or not hiring them, was based upon that protected status. Here, we would basically be forced into a legal dilemma. Do we ask about your status as a military member to make sure we're in compliance with this provision, that we don't have you sign an arbitration agreement like we have all other employees sign? Or do we ignore it to avoid a discrimination case under the Fair Employment and Housing Act and then deal with the provisions of this contract if, in fact, you are a member of the military and we had you sign an arbitration agreement just like every other employee? It's a litigation problem for employers, and again, it's likely preempted by the Federal Arbitration Act. For those reasons, we are opposed.
Thank you. Next witness in opposition.
Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California. We share Ms. Barrera's concerns that the Chamber enumerated. I want to address a couple additional points beyond the federal preemption issue. The first is the allegation that private arbitration is essentially unregulated, a private industry where anything goes, and that arbitrators are unregulated. There are numerous court decisions and clearly a number of statutes that are outlined in your committee analysis. So it is regulated in many instances, and there are specific provisions for when a contract award can be vacated in the Code of Civil Procedure. Similarly, there are mandatory disclosure provisions related to arbitrators. There are extensive judicial council rules that were adopted in California in 2002. Our arbitrator disclosure rules are much more extensive than those applicable to judges. Moreover, the two largest providers of arbitration services, AAA and JAMS, have extensive disclosure rules. And so there is extensive regulation of arbitrators and the arbitration system. We believe that arbitration is cost-effective and timely. I realize that the critics, opponents of arbitration, feel differently, and your analysis states that it's costly and unreceptive to consumers. 15 years ago, the California Supreme Court came out with the Armendariz decision and requires 5 items to be in a mandatory employment arbitration agreement that would be applicable in this instance, one of which is cost to be borne by the employee. Those are all borne by the employer. In fact, under the AAA rules, an employee filing an arbitration claim can pay no more than $250. All other costs are borne by the employer. We find studies extensively show that employees and consumers do better than, or at least the same as they do in court. For example, a recent study, 65% success of employees in arbitration, 61% in court. Of course, speediness is one of the most essential components of arbitration. The average arbitration takes less than 12 months. The average court decision is 2 to 3 years, 31 months in Northern California alone. We respectfully disagree with the proponents that somehow arbitration forces you to waive constitutional or statutory rights. We know that the 7th Amendment applies to criminal cases. But more importantly, just because you sign an arbitration agreement does not mean you give up your substantive rights. For example, you can't force an employee to sign an arbitration agreement and pay them a lower minimum wage. You can't pay based on gender differently after the additional changes to the Fair Pay Equity Act of in SB 358 of last year. So you cannot waive those. Arbitration is a different forum, not a waiver of substantive rights. And finally, how are employees or veterans benefited by this bill? We think that disputes will simply go into our overburdened and underfunded courts. It'll result in greater delays in litigation. There will be additional costs on employees, even if they lose most fee agreements with attorneys. While they may lose and waive their fees, costs are often borne by the employees. There are often lack of lawyers in these cases. For example, Major Lively's wife just testified. She went through 25 lawyers to find one to take her case. So there's clearly a dearth of employment litigators here. And lastly, the beneficiaries are going to be the attorneys. Let me just cite 2 examples why consumer class action benefits lawyers and not employees or consumers. In Starks versus Jimmy Johns in the LA Superior Court, $5,000 to the named employee, a $1.40 coupon for each class member, over $370,000 fees for the attorney. In McCrary versus Elations Company, $5,000 to the named plaintiff, $6 per class member, up to $18 for drinks. Plaintiff's counsel, $362,000 in fees, $585,000 in costs. We don't see the benefit to the employees with the elimination of arbitration and employment disputes. Thank you.
Thank you. Additional witnesses in opposition. We had 3 in favor. I'll take one more testimony. Otherwise, name and affiliation, please.
Good morning, Chair, members. Ken DeVorth, the National Federation of Independent Business. And as an Army veteran myself, I have the utmost respect for the military. But as I could not possibly do better than Ms. Barrera did, we oppose based on those very specific reasons. As small employers, we're caught between a hammer and an anvil on the questions we can ask. And we're trying to limit our expenses, our court expenditures, and so we ask you to oppose this bill. Thank you.
Thank you. All right. Additional witnesses in opposition, just name and affiliation, please.
Cliff Costa on behalf of the California New Car Dealers Association, in strong opposition. Thanks.
Brian Little with the California Farm Bureau Federation in opposition.
Thank you. Additional witnesses in opposition, anyone we've missed on either side of the aisle? All right, let's bring it back to the committee, and I'll entertain questions or comments from the committee. Mr. Holden.
Thank you, Mr. Chair. I wanted to kind of get your reaction to a couple of things. First, as it relates to AB 465, which the governor did veto last year, the wage theft bill. He gave in his veto message broad a review of how or more blanket prohibition on arbitration in all employment cases. And it seemed that the governor was looking for, in the future, more specified, targeted legislation. So the first question is, do you believe that your legislation, as it focuses on military men and women who serve our nation, is the kind of targeted, specific legislation that the governor was looking for when he vetoed 465? And then the second part of that is, as it was brought up by the opposition of the Federal Arbitration Act, what weight did the governor give to review of that legislation as it related, or that law as it relates to future arbitration type cases like the ones you have before us?
Yeah, let me answer that also by in addressing some of the concerns that were raised, because if you listen to the testimony in opposition, they are opposed to changing the way California weighing in on arbitration clauses in general. What we have is a situation where a service member will enter into an employment contract, and we're not trying to interfere with that or change that contract. We're not trying to ask the employer to ask any other questions about what they're trying to engage in, or a background of the potential employee, like, are you a service member, any of those questions. And a contract is a relationship between the contracting parties that effectively creates the law. So for the state to step in, we need to do certain things. We need to state, as a matter of public policy, there's something in that contract we want to change. So as to the governor's message, I think he's looking at the bigger picture arbitration. And this is very specific because there's very clear federal law, and I use it as a term, but it's the USERRA, Uniform Services Employment and Reemployment Rights Act. That's the USERRA. So there's very clear law that says that the employer-employee relationship with respect to a service member, the employer cannot do anything to discriminate against that service member. Okay, that's federal law. That also supersedes any of the arbitration, sort of anything that we're talking about. We have a situation where, because a service member goes into an arbitration, and it's binding arbitration under the terms of that contract, and then has no further remedy, even though there's an overlying federal law that says you have certain rights that the states or your employment contracts cannot abrogate, right? That arbitrator who gets it wrong, which is where we have too many of these cases starting to show up, that the arbitrator gets it wrong, the employee is told you have no further rights, you have no way to get into court. What we're trying to do is create a way to get into court. So the service member could then say, wait a minute, the application of my employment contract under the terms you're trying to give it to me, because of the federal law that protects me as a service member, that is unconscionable. Now, that's not necessarily a pejorative term. It's a contract term that gives the state, a government, leverage into a contractual relationship that the state is loath to want to interfere with. In fact, that's why we have contract law, so that we dictate how contracts are formed, because once they're formed, we don't want to mess with them in any inordinate way. But in this case, because the application of that contract is prejudicial against a service member, and there is a federal law that protects that service member, we need a way in to say, time out, those federal rights supersede this contractual relationship, because you are now discriminating against that individual and not giving him or her their rights under federal law. That's why under state law, we're going in through a contract mechanism. And again, I appreciate the opposition, but they're working against what those bills were last year. It occurred to me that there are certain classes here, including those of the military, who are potentially on the table as we continue, and we will continue to fight over arbitration clauses. This is not specific to arbitration clauses, but the examples that I do have were arbitration clauses that worked against a member of the military. What I'd like to do in this bill is take those active duty military and reservists out of this fight over arbitration, because they have compelling national nationally driven, federally driven rights to be protected in their employment context because they're service members. Let's get them off the table. Let's give them an avenue to get to court. And then they're not a part of, as we will continue, as you heard from the opposition, they're concerned about how California, how we've proposed in the legislature to move forward with arbitration clauses. Let's get the service members out of that conversation. Let them have the benefit of their employment and the benefit of the service that they're providing to this country and all of us, and not have them in the middle of this back and forth fight. Because again, if you listen to the opposition, they're talking about the bigger fight that we're having, not this specific class. I would hope the governor would say, all right, I get it. And because uniquely in this case, we have federal rights given to a service member under USERRA, that has to trump this state-created contractual relationship between an employer and an employee, and allow those federal rights to then get to that individual who should get the benefit of them. That's what we're trying to do. And so I would think that if we can get this through, that's the argument that I'm hoping the governor will pay attention to and say, yeah, we don't want to interfere with the federal USERRA in this context, and we should be stepping in. We should create a construct in California to ensure that those federal rights are always going to win out should there be a dispute between an employer and an employee.
I agree. I think that you make a very good point, and I guess I was just trying to get, and it sounded like in your answer that the governor may, and I just was trying to discern between the governor's view of what he was viewing as the larger case and the opposition sort of making that argument. Are they seeing it the same way, or by having language in his veto message that says that we'll look at more targeted specified legislation and de jure legislation? It sounds like I'm reading between what you said.
I would think so. Having looked at that veto message, this bill doesn't really come out of that. Not trying to find one of those categories, because again, we have this larger battle that we will continue to wage.
Right.
Fine. The governor's looking for a little bit more specificity around that. In the meantime, we have a case where we have individual employees, not that many, but enough, who have the benefit of the USERRA, this federal law, because they're military members.
Right.
Why are we playing in our fight? Why are we bringing them in the middle of that fight? So I would hope that the governor would see, not just because this is a narrow group, right? And again, that's not really where this came from. This comes from the USERRA and the state and federal laws trying to protect military members. I would think he would say, yeah, that should take precedence, USERRA and the protection of military members, over whatever it is we're fighting about here around arbitration clauses.
Right. I'm prepared to be supportive of your legislation or your bill. I just wanted to, in my own mind, you know, if a bill starts moving along and ends up on the governor's desk, even though they may not be completely in a line, and it may be a larger conversation that's going to be happening out there as we go forward, will he use that as a basis on which to say, well, this is similar, and therefore veto your bill as well? Or, well, you know, in vetoing these other bills, I did leave the door cracked to evaluate on a case-by-case legislation that was targeted. And I'm not, because we are trying to pull this group out and out of the larger conversation.
And in a way that does, this is very targeted. And again, because of USERRA, we have federal law that's not being applied appropriately. Shame on us that we don't have the mechanism to do that. And that's what I hope would be compelling to him. Not only is this targeted, but again, that veto was done, as a lot of the testimony and all this, really in the context of that larger debate over applicability of arbitration clauses and preemption under the Federal Arbitration Act, all of those things. That's what you heard. That's where that veto was when presented with this very narrow bill and the reason for it. I'm hoping that he'll say, I understand that. But that's one of the great things about Governor Brown. He looks at everything as it comes to him and makes a decision based on that. So far be it for me to predict what he may or may do on this, but that's exactly what we're trying to do here. is to get this group of individuals, because they don't deserve to be in the middle of this fight. They've got their own fights on our behalf.
Ms. Garcia.
Thank you. And more of a statement, just piggybacking on Mr. Holden's point. I don't want to belabor it on either side. I do have concerns given the veto message we got last year and the case we heard about of whether or not this group is nested within the larger or if there is the possibility for that exemption that you're trying to make. And at the end of the day, I guess we're testing that out. I get where you're going. I'm going to be voting for this bill today, and we're trying to read or see the tea leaves of where the governor might give a space. But I do have concerns about that. I sometimes have concerns about are we running in circles or not? You know, should we take the message we see here in front of us? But I think this group, our military personnel, merits us fighting for them and, you know, making sure they're not caught in other fights. So in that sense, I get where you're going with this. I will be voting for this, but I did want to vocalize those concerns, and you know, as we move forward in this committee.
No, I appreciate that. And again, the impetus of this bill was not to try and find a way through the governor's veto message, really trying to take that population out of this fight, and we'll deal with trying to narrow that conversation around arbitration as we move forward. But given the examples that came out of those conversations, I thought, wait a minute, this is a population we can deal with. It should be, I thought, straightforward to deal with them and get them off the table so that we don't have them in the middle or being impacted as we move forward, trying to have the debate about arbitration clauses in general.
Additional questions? All right, let me jump in. I guess I appreciate what you're trying to do, but you can't do it. And let me explain my view of it anyway. And I think I am in agreement with the governor and what he expressed in his veto. Well, let's wait and see what these court decisions do. And the court decisions, as Ms. Barrera said, came out pretty clearly that we can't do what you're intending to do. You want to take out of the conversation the members of the military. And that's, you know, in dealing with a state-created contractual relationship, which was your phrase. Well, we're not dealing with state-created contractual relationships. We are interfering in private contractual relationships. But it's not our job to take out of the conversation any one group of folks. Yes, there's USERRA out there. There's also the FAA, Federal Arbitration Act. They're both federal laws, and they have to work together. Whether they do or whether they don't, they work up here, and under the preemption clause of the supremacy clause of the Constitution, we're down here. So it's the job of Congress to take these folks out or not as Congress sees fit under federal law. It's not our job because the Supreme Court has told us in DirecTV, it told us in Concepcion that we've got to respect the Federal Arbitration Act. It is equally federal law, just like USERRA. So it might be nice to try to take these folks out. If you want to do that, write to your congressman, because that's the level at which this discussion, in my mind, ought to be had. And that's why, to answer your question, how in the world can the chamber call this a job killer bill, I think it will very effectively kill jobs for our active duty or our reserve military officers, because who wants to get involved in this kind of a fight that's going to go to federal court, that you're ultimately going to prevail at, but you're going to prevail at it at the Ninth Circuit, or you're going to prevail at it at the Supreme Court if, you know, like they did in DirecTV, they come back and say, you know, here's the rule, and this time, California, we mean it. That's why it's a job killer. You know, the idea that an arbitrator gets it wrong is as true as the sun comes up in the east. We all get things wrong at times. This legislature is not exempt from that. You can't fix every individual wrong decision at the state level, in my mind anyway, with a wholesale abrogation of what is federal law and has been reinforced by our Supreme Court numerous times, with California in the crosshairs is federal law. So I got to be a no. I got to believe the governor vetoes this again on the strength of those California Supreme Court decisions, and that's just where I am. You may close, I suppose.
Thank you. No, I understand that, except that in all of those cases, we have not had the circumstance of a federal law like USERRA, and where the creation, and it's not, the arbitration contracts are not state created. Contract law is state and federally created. Private agreements are created under the authority of our contract law. We dictate terms before contracts are entered into. That's how we frame contracts. Now, because an employer can't ask whether a potential employee is military, is active duty military, I mean, we have solved that. It's not going to interfere with that relationship going in. But what we're trying to do is when the employer is discriminating against an individual because of the fact that they're military, active duty military, or reserve, that's what we're trying to stop here. The employer has a contract, and it's naturally going to go to that, should there be an arbitration clause, is going to go to that binding arbitration clause and try and end that dispute. Now, we have plenty of cases that have arisen where the other federal law here, USERRA, not the Arbitration Act, is being frustrated directly because the arbitrator got it wrong, and that employee has no other avenue. I think it is our responsibility to make sure that we have devised a system here that allow us to enforce both the Arbitration Act and USERRA in a way that provides some consistency and protections for individuals who are in active duty military or in the reserves. That's what we're asking to do here today. That's why I think, even with the governor's veto message of the broader arbitration bills, I think we have the ability to go to him and say, let's just settle this, give a path for those active duty military here in California. That's what we're trying to do. Let's get them out of the broader arbitration decision. And true, the Supreme Court will do what the Supreme Court says, and given the history of the state doing what it's done, if that frustrates the Supreme Court, it might frustrate the Supreme Court. But I think we have a pretty good argument here to say, because of the federal law, Arbitration Act and USERRA, that should work together. I'm happy to write to my Congress member. I'm not actually optimistic of Congress settling any of these things in the near future. So why don't we do something that gives that active duty military reservist who has been prejudiced by the application of the way the system works in California, give them another opportunity or a real opportunity to say, wait a minute, I have these rights, you have to take these rights seriously.
So is it your view that we could, as a legislature, write a law that any time an arbitrator gets a federal decision, a federal law wrong, federal housing, federal employment, federal minimum wage, although ours is higher, federal discrimination, gets a federal law wrong, we can write a law that says that case won't apply under the FAA, and therefore we can have our employees go to court?
I'm not saying that at all. I'm saying under the case of USERRA,
just USERRA,
active duty military,
okay,
and reservists, because of their special place in what they do for this country and the rights that they have, we should be mindful of those rights and make sure that the system in California is set up to protect them.
Is there anything?
That's all I'm saying.
Is there anything in USERRA that says this is different and more important, and therefore states can get around it, than the discrimination, the wage, the you name it, other federal laws? Or is that just you think it should?
USERRA says you cannot discriminate against active duty military or reservists in employment, that they have the right to perform their military duties, and you cannot hold that against them. That's what USERRA says. Where that happens, I think it's our duty to find those instances and protect those employees. That's what we're doing here. I'm not going to comment on any other federal law, any other circumstance. I'm looking specifically at the issue of that contractual relationship between an employer and employee, knowing we have USERRA, knowing we have the Arbitration Act that's out there, the Federal Arbitration Act, and saying, how are we as California being responsible to those employees who are active duty military? Okay.
All right. I said you could close, and then I jumped in there. So go ahead and close. I'll be quiet.
Thank you.
All right. With the close, I'll entertain a motion. The motion would be to approve and send it off to labor. Motion by Mr. Holden, second by Mr. Ting. Call the roll, please.
Thank you.
Stone?
Aye.
Stone, aye. Wagner?
No.
Wagner, no. Alejo? Alejo, aye. Chow? Chu? Aye. Chu, aye. Gallagher? No. Gallagher, no. Garcia?
Aye.
Garcia, aye. Holden? Aye. Holden, aye. Mainshine? Mainshine, no. Ting? Yes. Ting, aye.
And that bill is out. Thank you.